So there's uncertainty about the delivery of the decision. There's a notice from the registrar to Lisa Schumann, counsel on record and local counsel in Belize for Caleb, indicating that the Chief Justice would deliver his decision on the 27th, which is next week, Wednesday. However, there has been no follow-up formal notice issued by the Supreme Court that the decision will actually be delivered on that date. Also, there's nothing on the agenda for the Chief Justice on that date, and the other lawyers involved in the case appear to have not gotten that letter as well. And there are also reports that the Chief Justice is unwell. So far, it doesn't look promising that next week, Wednesday, the decision will be delivered, but we're closely watching it, and Counsel Belize, Lisa Schumann, is keeping us abreast of those developments. To now turn to a little bit about the background, and sorry the reading there is so fine, but I just want to give you a little bit of quick context to the litigation. And in 2007, it started with a regional assessment, a desk review of 5 countries to determine whether there was a reasonable case to be made before constitutional courts about the constitutionality of laws criminalizing same-sex sex. That was done by me and Prince Netta Wade, who is a PhD student at NYU, then an LLB student in the faculty. By 2008, there was a review of that regional assessment, a small review of UWI teachers, along with a representative from LGBT civil society, SASA, Joel Simpson, and a Belizean lawyer, because there was a strong sense from that report that Belize was the most favorable environment on paper to litigate. By 2009, URAP was formalized by academic board at Cave Hill, where the Faculty of Law was then based. And then between 2007 and 2009, in a series of 4 meetings held by CVC or in collaboration with CVC, there were discussions with LGBT civil society about the possibility of litigation. Some of those discussions included Caleb, and within the context of those discussions, there were direct discussions with Caleb about the possibility of a case in Belize, which on the assessment we made was the most favorable legal environment in which to bring this case. By 2010, some additional work was done to evaluate the socio-political environment in Belize. An independent assessment was done by a human rights lawyer, and there were 3 visits by both URAP and CVC to Belize to meet with different constituencies, including the larger LGBT community, lawyers, academics, persons involved in HIV work, some people close to the government, other human rights groups, and so on. By 2010, July, the case was launched in the Belize Supreme Court. By then, at that stage, it was the end of the former Chief Justice's period there, and by the time the case was heard 3 years later, with much problems in trying to get to that stage, there was a new Chief Justice in place, Chief Justice Benjamin, and Justice A. Carrie Flags was present at that hearing in 2013. It also had an agreement with us, which had been developed about issuing joint press releases on the major issues. And URAP commissioned a report by Caleb Orozco and Vidyaraka Kisoon from Guyana, which was presented to Carrie Flags to offer information to Carrie Flags about how that litigation was going, how strategic litigation worked in that particular case, the strengths and the weaknesses. I'm not going to go through this, but this gives you a matrix of how URAP made assessments about whether litigation made sense. And that included looking at some structural legal considerations, which we call them, looking at the Constitution, looking at the law, some political legal considerations, thinking about are governments going to try and undo positive litigation and positive outcomes, for example, because you don't want to litigate somewhere where they're going to use constitutional reforms to undo. So you want there to be strong support for litigation. And thirdly, some socio-political considerations. What's the attitude of the church? What is the risk to the litigants, potential litigants in the case? Are there civil society organizations with the capacity to support litigation in that country? What's the attitude of the society? Those were some of the considerations which were used. Just to quickly point out the parties and the lawyers. So in this case, there are two parties. There's Caleb Orozco, who is an individual and has been a leader of UNIBAM for many years, and the Attorney General of Belize. Everybody else is an interested party. The first set of interested parties who joined the case were joining in support of Orozco, Human Dignity Trust, the International Commission of Jurists, and the Commonwealth Lawyers Association. And they were the first to join as interested parties. That created a fair amount of unease in Belize and led to an anxiety that the case really wasn't being led by Caribbean forces, but by outsiders, even though they were interested parties. The follow-on knock-on effect is that 3 sets of church organizations also joined as interested parties: the Anglicans, the Catholics, and the Evangelicals. That's kind of more or less everybody on the Christian side of the community. And then the judge who was hearing the case then, Justice Arana, knocked out UNIBAM as a direct litigant from the case, claiming that they didn't have sufficient interest to bring the case and were personally affected. And ultimately, although we tried to rejoin them as applicants, that didn't succeed for a range of reasons, and UNIBAM is now an interested party as well. So this case is just Orozco, an Attorney General, with everybody else interested parties. The case is led by Christopher Hamill-Smith, who is a Trinidad and Tobago lawyer living in Barbados. The counsel based in Belize with the most direct involvement in the case is Lisa Showman. Also is a Belizean lawyer, Simeon Sampson. And finally, on the legal team on record is Westmin James, Deputy Dean at Caville, Barbados, who is a URAP team member. Although URAP has general conduct of the case, these are the lawyers who are on record. The law in question, which is section 53 of the Belize Criminal Code of 1981, states that every person who has carnal intercourse against the order of nature with any person or animal shall be liable to imprisonment for 10 years. Initially, I thought this was simply a copying of the Indian Code, which you hear a lot of discussion about. Section 351, I think it is, of the Indian Code, which gave rise to the NAS Foundation litigation. I know I'm better informed, and I'm told and understand that Belize did not, in fact, adopt the Indian Code. They adopted a code which was meant for Jamaica by a man named R.S. Wright. And R.S. Wright developed a code for Jamaica which was accepted in Jamaica and then repealed, never became the law in Jamaica. However, it was adopted in St. Lucia, in British Honduras, in British Guyana and Tobago. That's significant because Wright's code was far more lenient and severe in relation to sodomy than the code which was in India and the positions in the UK, in England at the time. As a consequence, up until 1940 in Belize, the only thing that was criminalized was the unnatural crime without consent. And that was until 1940. The only thing that was criminalized was non-consensual, unnatural criminal behavior. And that's interesting because we all assume that everywhere in the Caribbean, and I think if you, as activists, if you begin to look at your experiences in places like Guyana and St. Lucia, you may find that you have had a slightly different context there than in places like Jamaica, which could have ended up with that, or something close to that, but it was ultimately rejected. That places like St. Lucia, Belize had criminal codes. Places like Jamaica and Barbados didn't. What they did was they consolidated criminal laws in one place rather than created a code. So if you look at the Belize law, you will see like 300 provisions in their criminal code. If you look at Jamaica's Offences Against the Persons Act, it's probably under 100 provisions. So there was also a different way of organizing those laws in different parts of the Caribbean is what I'm saying. Finally, what I wanted to say is that the unnatural crime is not the same thing as buggery. So the law in Belize is not the same thing as the law in many other parts of the Caribbean, which identify buggery as a crime. Buggery is the crime of having anal sex by a man, and in some places it includes with another human being or with an animal. However, the unnatural crime, according to authorities elsewhere, is broader than buggery, and it includes the use of, by a man, of his penis in a way which imitates penetrative sex. So, with the use of the hands of somebody else, oral sex, the use of the other parts of the body of someone else, the use of the mouth, the use of the hands. So the unnatural crime is potentially much wider than buggery or sodomy. What's the difference between buggery and sodomy? Everything I have learned suggests that sodomy has stronger resonance with church law than the terminology buggery, but they are almost interchangeable. But when you see the term sodomy in spaces and in legislation, you can generally find a stronger connection between that and what was ecclesiastical law. So these crimes all started as ecclesiastical crimes, which moved to the civil domain. And they were criminalized before the post-slavery period, which is when most of us knew of the law. So yes, we trace our current laws to laws passed after slavery, like the Offenses Against the Persons Act, and other pieces of legislation where there was an attempt to reorganize criminal law. But buggery and sodomy were crimes at common law, and often crimes under laws which existed during slavery as well. Why have we given so much attention to what happened after slavery? Part of it is that the penalties changed after slavery. It used to be a penalty of death in many places, and the penalty changed after. And not only that, there was an organized police force after. So it was easier to prosecute. The first people prosecuted throughout the Caribbean for buggery and sodomy were often in prisons, where there was already surveillance. There was no police going out and policing people. But the fact that there was a more formal prosecution force after slavery, the fact that there was also a formal police system, a more formal policing system, meant, and that the penalty was not as onerous as death, meant that you saw more prosecutions after slavery than before, even though it was criminal before. Just to say, since May of 2013, when this case was first heard, 3 years ago, the Indian Supreme Court has ruled in the Nas Foundation case in ways which are very conservative and very different from the ruling of the Delhi High Court. The ruling of the Delhi High Court, which is a phenomenal ruling, was widely relied on by the legal team for Orozco and Uniban. The fact that that decision was taken back and reversed by the highest court in India is a major blow to Orozco's case, and we don't know yet what it will mean when we see the decision of the Chief Justice. Secondly, since the hearing of the case, as you all know, there's been a dispute about the evidence provided by Professor Brendan Bain, who was invited to give expert evidence in relation to HIV and criminalization by the interested parties who are the churches. I'll come back to that. And since then, a few weeks ago, a ruling by the CCJ in the case of Tomlinson and the consistency of immigration laws in Belize and Trinidad, which bar homosexuals with the RTC, with the Treaty of Chaguaramas. Finally, those are all things which might be possible negatives. On the positive side, there's been a consolidation in international human rights jurisprudence. There's very little dispute in international human rights law that criminalization is inconsistent with international human rights. However, there is a lot of contestation at the UN Human Rights Council, for example, in Geneva, about what it really means to say LGBT persons are entitled to human rights, and that contestation is strongest from countries in Africa. Caribbean countries have been in some cases neutral, in some cases also hostile, and then there have been a range of other states but there have been major successes recently at the Human Rights Council level. So in relation to the main arguments, I just wanted to point out that although international human rights is clear on criminalization being inconsistent with human rights, foreign law, when you look at what other constitutional courts are saying across the world, the position is a little more mixed. So the main argument for Orozco, two main arguments, are that Section 53, which is the unnatural crime, which essentially criminalizes men, although men in relation to different kinds of conduct, that it breaches the human right to dignity in the Belize Constitution. And the lawyers for Orozco have argued that human dignity is the fundamental right which underlies every other fundamental right. Secondly, the lawyers are also arguing that Section 53 breaches the right to privacy in the Belize constitutions. Those are, on our assessment at URAP, the two strongest arguments which we have presented. We've also presented three other kinds of arguments which we assess to be weaker than those two. Not weaker in principle, weaker in the context of the Belize Constitution. One is, we also argue that it violates the right to equality and to equal protection of the law. We argue that it violates the right to freedom of expression and the right to non-discrimination. In principle and internationally, the strongest arguments would be the equality arguments and the non-discrimination arguments. But in the context of Belize, non-discrimination has listed grounds of prohibited discrimination, and sexual orientation, as you can well imagine, is not listed in those grounds. And there's generally a feeling that one does not try to squeeze it in on the sex, even though obviously that was the anxiety which gave rise to the Jamaican constitutional reforms. But generally, international human rights tribunals don't agree that the proper approach is to try and subsume it on the sex. They have argued that the open-ended protection against non-discrimination also contemplates sexual orientation discrimination. That argument is less possible in Belize because it has a list, and the list on the face of it seems to be very closed. Equality is not closed. I would argue not in Jamaica, not in Jamaica's Section 13(3)(g), nor in Belize. But that is an argument we are making. It is not one the courts of Belize have ever yet accepted. So we don't see how a Supreme Court will accept our argument, which contradicts the way the Belize courts have viewed equality up till now. We think a Court of Appeal could, or the CCJ could. So we don't consider the equality argument dead, even if we lose here. We think it's an argument a higher court could take up, because they now have the authority to act differently to the way in which a lower court has. And then finally, freedom of expression, an interesting argument, but we have no strong authorities anywhere which have said this is a very strong basis on which to hold criminalization is inconsistent with the Constitution. So just quickly to say who must prove what. Orozco's job is to prove that his constitutional rights have been infringed, and then he sits down. He has nothing more to do than to say his privacy and his dignity has been infringed. The burden then shifts to the Attorney General of Belize, and I could say in actuality, the case was more vigorously argued by the churches than by the Attorney General. The Attorney General then has to say, yes, his rights have been infringed, but there are good reasons to infringe his rights, which outweigh the right. In other words, there's a justification for limiting those rights to protect the human rights of others. And the argument which is canvassed, and it was canvassed in the case, for why you could justify limiting his rights was that the idea that there is public morality, or public morality claims at stake, which outweigh his privacy rights or his dignity rights. Just to say, the Constitution of Belize specifically talks about public morality as a legitimate reason for limiting fundamental rights. so that it comes not out of the air, but it comes from the constitutional instrument as well. What's a victory, according to Caleb's team? Caleb's team considers a victory to be an instance in which the Supreme Court of Belize, the Chief Justice, rules that any of his rights have been infringed by Section 53. Any one of them. But we think it's more likely to be dignity or privacy, and that the result of that infringement is that Section 53 is not consistent with the Constitution of Belize. If the Chief Justice says that in relation to any single right or multiple rights and concludes that the law is inconsistent, that's a victory. How big a victory depends on the details, but that's a victory, because the result will be that the law cannot stand, Section 53. What's a loss? Everything else is a loss. Everything else. If he says, yes, the rights have been infringed, or some right has been infringed, but there's a justification for it, that's a loss. Not as bad a loss as if he says, no, there's been no infringement of any constitutional rights of Orozco. That is a profound, devastating loss for Orozco's team, and he and others will respond strongly if that's the position. Because there is no wide support for the idea that it implicates the right to privacy, equality, dignity. The likelihood of an appeal, absolutely certain. No matter what happens at the level of this case, there is going to be an appeal, almost certainly. Even the best outcome for Orozco and his team is likely to be a mixed one. It's likely to be one in which you win on some points, you lose on some points. Even Orozco, if he meets the criteria of a victory, is likely to say, I want to cross-appeal certain points. On our interpretation, the interested parties may have a right to appeal as well. So even if the government isn't strongly interested in an appeal, the interested parties, and interested party status is a phenomenal new development in Caribbean constitutional law, which all of us have seen the implications of. And so we should expect an appeal. And so that should also help to determine what the plan of action of civil society organizations will be, because this will not be the end of the case. The case will continue after this. Some other important questions arising from the case. Firstly, the Belize Constitution and a few others in the Caribbean talk about the supremacy of God in the Constitution. What does that mean? Does it mean then that we have to follow what the interested parties who represent churches say? And the answer is no. The first is that even in litigation brought by churches, for example, and this is, I think, a useful debate in the context of Jamaica now, with nurses and other professionals at Andrews Memorial Hospital, which is a Seventh-day Adventist hospital, teachers at Catholic schools in Belize could not continue to teach if they were pregnant, because they had signed a contract that they should observe the teachings of Jesus Christ. The court, the Chief Justice, held that that contract was constitutionally impermissible, and that Belize, even though it talks about the supremacy of God, is a multi-ethnic, multi-faith, and a secular state. So we have strong jurisprudence that even though it talks about the supremacy of God, it is still a secular state with a separation of church and state with respect for fundamental human rights. So what does supremacy of God mean? We're not really sure. We can look to Canada, which has exactly the same provision in its Charter of Rights and has tried to make sense of it. But it's not so clear. Here's what, the most we can say is what it doesn't mean, rather than what it does mean. It doesn't mean that there's one religious view, which must be privileged. So it doesn't mean that three interested parties who represent 90% of Christians in Belize get to articulate what God's position is and to enforce the supremacy of God. That's not what it means. Because one, the idea is that there are multiple religious faiths, all of whom are constitutionally protected in the free exercise of their religion. But it also means that there are multiple religious views about the human rights of LGBT persons, and I give you the example of Belize. This case is, against this case is the Anglican Church of Belize. But Chief Justice, Archbishop Desmond Tutu has strongly said that his understanding of his church and faith always recognizes the human rights of LGBT persons. You may know that the famous Wolfenden Commission in the 1950s, which gave rise to decriminalization in the UK, which was the starting of their decriminalization, that committee had the support for decriminalization from the Anglican Church. That's what, 50 years ago? More than 50 years ago. So when you wonder about the response of Anglicans, which sometimes feels different from other faith-based leaders, there's been a history of less opposition from Anglicans, particularly to decriminalization. And faith-based leaders have often offered different views on decriminalization from marriage. Some offer similar views on both. So there simply isn't an argument that one religious view can be given preeminence as a result of this clause on the supremacy of God. Finally, it's not finally, so Roscoe argues that his rights have been infringed, but is there a case for saying that Orozco's rights haven't been infringed because he has never been arrested? So can he say my privacy has been infringed if there's no instance where he has had the police come to him and say, we are going to arrest you or we have arrested you, which is not the case here. Well, there are countless authorities which indicate that he has standing to bring the case even though he has never been arrested. And I see Westman coming in onto the call. Westman is the lawyer from the URAT team in the case. And we don't have any sense that this is strongly objected to by the parties, that Caleb is a proper applicant. I think the risk is that it will come up not on whether he has a right to bring the case, but whether his rights have actually been infringed. And I'll tell you the reasons why I'm a little bit concerned. One is the narrow ruling of the CCJ in the Tomlinson case, which says, well, Belize and Trinidad weren't enforcing the Immigration Act, which says we won't admit homosexuals, and that for us opens the door to a very, to interpreting or the obligations and whether they've been complied with in a very liberal fashion. And so they said you can't exclude homosexuals, but if you're not enforcing the law, then we won't take the position that Tomlinson's rights have been infringed. Yes? The risk is that with Caleb, that because of the CCJ ruling and the decision to deliver the decision is timed immediately after the CCJ's ruling, which might suggest that the Chief Justice is paying attention to what the CCJ, which is the final court of Belize, Court of Appeal for Belize is saying, there's a risk that he will find a way to avoid a decision on the case by holding that Caleb has not faced enforcement of this law. And because he hasn't faced enforcement, then his rights haven't been infringed. We would not have raised this concern until we saw the recent CCJ decision. The second possibility is that the NAS Foundation case, the Supreme Court decision of India, also suggests a very limited understanding of the law. And that limited understanding is to say, well, this case has a law which you're arguing has a discriminatory impact on gay men. But we're not convinced that that's so. You're saying gay men face threats, more vulnerability, extortion by the police as a result of that law. If that's so, it's incidental. It is not an intrinsic element of the crime itself. It is an incidental effect, and not reason enough to say it's unconstitutional. So both the CCJ ruling and the NAS Foundation ruling might have an impact on what the Chief Justice says. Then to also point out that in a range of cases we have seen, including this one, Caribbean courts consistently limiting litigation, public interest litigation being brought by LGBT civil society organizations. They did it in the Belize case in relation to Unibam, who they struck out, and they said, how can an organization have privacy? They have no interior emotions, no human body or self, to have a privacy right which is infringed. We came back and argued that they were representing persons whose privacy interests were infringed. Unfortunately, we didn't get an opportunity to argue that point. In Guyana, where we were last week, we also saw SASOD ruled out of the case and struck out, and an aversion to SASOD rejoining even to litigate its own case about its being excluded from the litigation at the appeal stage. And SASOD was ruled out because Gulliver McEwen, who is one of the individual litigants, and 3 others were in the case. And the then Chief Justice said, well, if you have 4 people directly impacted by the law here, why do you need an organization? It arose, as far as I know, in relation to the CCJ case with Tomlinson, and I believe I see Colin in Trinidad, but either with carry flags or CAISO, this limited ruling on standing came up. And then last week in Jamaica, it came up in relation to the public defender's desire to join the Tomlinson case, now a case challenging the Buggery law. So this is a strong theme which is appearing in all of the LGBT litigation.
But the churches are there as organizations?
Yes, yes. So everywhere churches have been given space.
As organizations?
As interested parties.
As a corporate body or as an individual representing the church?
No, as the Anglican Church or the Catholic Church or as Jamaica Coalition for a Healthy Society. So in some cases, the interests of religious groups have come through churches formally or organizations with a strong religious disposition, both. But not yet as individuals with a religious disposition, either church or organization. So this is a theme which will not come up in the litigation because it's already decided, has not been followed up by us at this moment. It has already been decided, but it is a theme which is obviously relevant given the decision in Jamaica last week and what has happened in virtually every single LGBT case in the Caribbean. And then a question which we were asked and put to us directly by lesbian and bisexual women in Belize is, how does this case affect us? It criminalizes what men do. Are we impacted by this case? And our answer was that you are, to the extent that everywhere laws like this exist. It has what Ryan Goodman, who is a professor at NYU, calls a panoptic effect on the LGBT community. And the experiences described by quality of citizenship in Jamaica, for example, confirm corrective rapes and corrective violence against women, which exist in a context where there's criminalization. So where there's criminalization, even though it doesn't criminalize what women do, the society takes the criminalization to be a broader condemnation of LGBT persons, and that has an impact on violence, and it also affects how all LGBT people behave, because they know that the attitudes of the society are partly shaped by criminalization. And then finally, in relation to lesbian and bisexual women, laws relating to criminalization are what we would call old new laws. So the old bits are gross indecency, sodomy, buggery, and the unnatural crime. But the new bits, which have all been introduced since 1986, introduce criminalization of women as serious indecency. Trinidad, St. Lucia, Antigua, in a range of countries which passed sexual offences laws from 1986 onwards, all criminalized women having same-sex sexual intimacy. And so in fact, in many parts of the Caribbean, not just men, but women are also criminalized. This case is important for women in that larger context of the Caribbean, as well as in countries where they only talk about men because of the panoptic effect of the law. Here's another issue which may come up. Who should decide this question? Is it the judiciary or the legislature? And we take note of NAS Foundation, where the Supreme Court said it was a separation of powers issues. It was for Parliament to decide the issue. And that is the most trusted avenue for judges who are reluctant to decide a human rights case. They say, no, this is an issue of democracy. The people must decide. It must be the Parliament that decides this issue, and we will not resolve it. Let the legislature settle it. We have a wealth of cases in the Caribbean which have taken this approach. We equally have a lot of decisions which have been critical of judges reneging on their duty to review laws which are inconsistent with the Constitution. In fact, the courts have said it is not just a power, it is a duty of the court to assess whether laws are inconsistent with the Constitution or not. Almost at the end, the very disputed evidence in the Orozco case from Professor Brendan Bain. I'm not going to say much about that evidence. I don't think the Orozco case will turn on that question. In other words, I don't think the judge needs to say one way or the other what his evaluation of that evidence is to decide the case. I think he can decide the case quite separate. In other words, it's not integral to his decision. However, just to advise you that the evidence, the expert report which was presented on Orozco's behalf comes from Professor Chris Barra and his team at Johns Hopkins, and he's, I think, maybe the world's leading epidemiologist and expert on the relationship between criminalization and HIV. And in the debate about Professor Bain's evidence, very little attention was given to what the other evidence was. And you will see that Barra accepts that men who have sex with men do have higher prevalence of HIV. And so his starting point is not different to Bain. Where he ends up after that is very different, because he says that criminalization from the research which he has done. So he cites, unlike Bain, whose evidence and studies cited were quite abstract, he relies on empirical research that he has done and others have done in the last couple of years to establish that criminalization reduces health awareness of men who have sex with men, it increases fear around healthcare delivery, it facilitates social discrimination and stigmatization, it encourages violence, it limits treatment availability and effectiveness, and it contributes to higher prevalence and incidence. So rather than pathologizing men who have sex with men, he's pointing out that criminalization contributes to poor access to health care and a range of other negative outcomes. And he says, in answer to the question, aren't there countries which have decriminalized, which still have high rates of prevalence of men who have sex with men with HIV? And he says, yes, that's so. But what you must remember is that eliminating criminalization is not enough to address the larger issues of discrimination. You must also address stigmatization and a range of other issues facing men who have sex with men. So he accepts that, as Professor Bain presented, that there are countries with criminalization, no criminalization and high prevalence of MSM, And he says that notwithstanding that, you should recognize that criminalization on its own is not enough. Decriminalization on its own is not enough. It is only the first step. So the reports don't contradict each other in terms of the basic facts, but they offer a very different reading and understanding of the context of men who have sex with men and criminalization. And the difference between the two studies, the two reports, expert reports, is that Byros cites current empirical research, which Baines does not. And Byros understands Baines' report, even though he hadn't read it. In other words, he speaks to the context which Baines speaks to, but the converse is not true. That Baines does not cite any of the reports which Byros mentions, which are now widely known reports about criminalization. And the requirements for export reports is that you should provide the whole story. If there's relevant information relating to criminalization, it is the duty of both Byros and Baines to present that information. So in some respects, one of the possible critiques of Baines' evidence expert report is that it makes no reference to the wealth of current research on criminalization and HIV, which is empirical. It is not theoretical. It's based on actual studies in places like the Caribbean. Notably, Byros' research is in Africa. And then finally, what remedy will the court give? I don't want to belabor this point, but there's a small technical point. If Orozco has a victory, what remedy will the court give? And I'm going to press on from there because it's a slightly technical point. And then I'm going to end by saying what are the implications for the rest of the Caribbean. I think the general implications are stronger than the legal one. And the reason why I immediately say the general implications are stronger than the legal ones is because Belize is the optimum country in terms of constitution and law to bring this case. No other country has the constellation of factors in law which come together to make Belize the ideal location. So you can't immediately say, oh, well, I'm in X country, therefore this decision means. Because other countries have slightly different contexts and are less ideal. So one is Belize is the optimum country to bring this. The second is we only have a decision of the Supreme Court if Caleb wins. It means that what we call the precedential value of the case, how weighty it is going to be to another court, is much less if it's only the decision of the Supreme Court. That precedential value increases when you go up to the Court of Appeal, but even then it is still undecided. That precedential value becomes really strong if it's either the CCJ or the Privy Council, in this case, the CCJ. And you will already have a sense that there are a growing number of countries which are now acceding to the jurisdiction in the OASIS region. Notwithstanding the limited legal impact, and let me just say something more about the limited legal impact. That limited legal impact will be affected by, is there what we call a general savings law clause in that constitution. Those clauses exist in Trinidad, in the Bahamas, in a way of fashion in Jamaica. What's the number 5? Guyana, have I said Guyana? So the 5 first independent countries have this most restrictive clause, Barbados. The OASIS countries and Belize have less restriction on challenging colonial laws. The second other big restriction is there an enforceable right in your constitution to privacy? And the challenge throughout the Caribbean is that outside of somewhere like Trinidad and Tobago, it is not so clear, and Jamaica has the problem of the savings law clause, it's not so clear whether you have an enforceable right to privacy. So there are difficulties in making the exact same legal claim made in Belize in many other Caribbean countries. Not impossible, but you may find that arguing that this case means in my country the law is not good may be a difficult argument to make. Nevertheless, there are more general implications. If the language of the court is positive about the human rights of LGBT persons, talks about their rights to privacy, equality, dignity, then even though you may have hindrances in specific countries to making the exact same claim, it will have significance throughout the region. It will change the way people begin to talk about the human rights of LGBT persons, and that will have the sanction of courts now for the first time. And the second thing is that even if it has limited precedential value, it can also provide an impetus for law reform, for international action, for changing the mood and the spirit of conversations about the human rights of LGBT persons.